This week on Government Matters.
It has only been reproduced in a lab environment, but as hackers become aware of vulnerabilities, they try to exploit them.
It could be the biggest smartphone flaw ever discovered. We detail the cyber threat to Android phones and its impact on government.
It's still a lot of information that they're getting, but it's not the wholesale telephone records anymore.
The National Security Agency will end bulk collection of Americans' telephone data, but there's a catch.
Our campaign finance laws are being whittled away by court decisions. For the government contracting community, that isn't the case.
A federal appeals court upholds the ban on political donations by government contractors. Will that case reach the Supreme Court? Government Matters starts right now.
From ABC 7 and News Channel 8, this is Government Matters.
To our viewers around the world on the American Forces Network and here in the nation's capital, thanks for joining us. Government is the engine that runs this city. That's why Government Matters. Every week we'll bring you the top headlines in tech, security, and management. I'm your host, Morris Jones. It's been a rough week for Android. Security researchers found a major flaw in popular operating systems, including a bug called Stagefright. Diane Cho gauges the possible impact on users and government.
If you have a fear of being spied on through your phone, you might want to listen up. New research shows Android users could be vulnerable to a hack without the user even knowing it. Cybersecurity firm Imperium first discovered the threat. Researchers say it only requires your phone number.
The vulnerability to be exploited before the user noticed anything, that is very dangerous.
Experts say the problem lies in a media playback engine built into the Android operating system known as Stagefright. If your device automatically downloads a photo or video sent by text message, the user wouldn't even have to open the file in order for the hackers to get in, gaining access to all of your data and your photos.
Android devices get software updates inconsistently, which is incredibly scary. It leaves users kind of at alert.
Researchers say the threat affects all Androids made in the last 5 years. Ironically, devices using anything below version 2.2 are the only ones not at risk. Android maker Google tells ABC News, quote, "We've already responded quickly to this issue by sending the fix for all Android devices to our partners."
While Google has published a fix for the Android operating system, it hasn't been pushed down to most devices. Android updates typically go through the device manufacturers and then they go through the carriers.
And so far, there aren't any known victims of the vulnerability. Rebecca Shen, the mobile security expert for Coolspan, says it's also important to note it's only been reproduced in a lab environment.
But as hackers become aware of vulnerabilities, they try to exploit them.
So what can federal agencies and businesses do to protect their employees?
They can usually control these kinds of settings via MDM or a mobile device management platform to kind of automate these settings for their users so the end user doesn't have to think about it.
Shen also advises users not to download any text messages with video or photos from people that they don't know or trust, adding that you can also go to your settings on your device and change the auto retrieve option so you don't automatically download those messages. For Government Matters, I'm Diane Cho.
The premier federal program helping severely disabled Americans get jobs is under investigation by the Justice Department. Confidential sources tell CNN billions of dollars designated for disabled workers is being funneled elsewhere. Drew Griffin has this special report.
The majority of the individuals that were being hired were not severely disabled.
This manager, who wants to remain anonymous to protect current employment, says instead of hiring severely disabled, the federal contractor making tens of millions of dollars would hire just about anyone who walked through the door. And no one bothered to check.
So you could say 100% of my employees are severely disabled.
Correct.
And none of them are.
Right.
And you'd still have this contract.
Right, because there's nobody checking.
Source America says they conduct on-site visits, but according to their statement, Source America staff does not determine compliance. Only the U.S. Ability One Commission is authorized to do so. How does it happen? Ability One's commission is made up of presidential appointees, but it outsources the management of the program to the nonprofit agency Source America. Source America recommends and, according to our sources, virtually decides who gets the contracts, worth $2.3 billion every year. Former congressional investigator Rich Butel says it's a recipe for corruption.
The contracts are now being funneled to a very small group of 10 large companies that are getting way more than their fair share.
No one from Source America would go on camera, but in a statement, the group flatly denies the allegations. No one involved in making award recommendations, the statement reads, is employed by an organization seeking those contracts. Butel and numerous other sources are telling CNN the staffers who are essentially handing out federal contracts at Source America are heavily influenced by top officials at the very same agency. And those officials are often connected to the businesses that get the contracts.
You have actual advisors and board members in these private organizations who are themselves business owners, and so they can award themselves potentially contracts worth hundreds of millions of dollars. A perfect setup for waste and abuse.
Drew Griffin reporting. The Digital Accountability, Transparency, or DATA Act was signed into law more than a year ago. This week, Congress got a progress report. During an IT subcommittee hearing, Gene Dodaro, head of the Government Accountability Office, didn't paint a pretty picture. He says the Treasury Department and the Office of Management and Budget have only issued 27 of 57 standardized data elements due by the end of the summer. Dodaro says the federal government does not have an inventory of all federal programs, so the data may not offer a complete picture of government spending. Committee Chairman Will Hurd says that's unacceptable.
I've been in Congress for 7 months, I think that's it, and my staff makes fun of me because I say the word outrageous a lot. Because as I learn more about how our government operates, it's pretty outrageous. And something as simple as understanding how the federal government spends money, I would think we'd be able to answer that question, and we can't. And we recognize that there's 57 pieces of data that we want to track, and that every agency may have one of those 57 pieces in a different database that doesn't talk to each other. Now, for me, it doesn't take 2 years to map that.
The Congressional Budget Office estimates the DATA Act will cost about $300 million to implement by 2018. White House officials say the success of the program depends on the appropriation of sufficient resources. First, there were 6 bids, then 3. This week, Leidos emerged victorious with one of the largest electronic health records contracts in history. The task ahead, next. In security matters, the Pentagon's next-generation health record system. After years of planning and competition, DoD just awarded a massive contract to defense IT firm Leidos. It will be worth at least $4.3 billion over the next 10 years. For more, I'm joined by Frank Konkel, technology reporter and events editor at the Government Executive Media Group. Frank, let's start with the price tag. It's worth repeating that $4.3 billion is the contract's base value. Tell me more.
Right. So the first 10 years or so have options on this contract that will make it worth, if all those options are exercised, around $4.3 billion. Now, the whole life cycle, the scope of the contract could be up to 18 years and almost double the value, which would put it around $9 billion or so.
Now, Leidos partnered with an EHR vendor named Cerner and Accenture Federal on this project. To many, their win comes as a surprise. Why?
Well, it was a surprise to many of us journalists in the industry as well. I think the biggest thing was Epic is considered the market leader in developing these platforms. So when IBM partnered with them, that was a huge coup, a big deal. Everyone was talking about that. IBM also made a big push in hiring a lot of defense experts in this field, and many of us have thought that they made the biggest push. Leidos was a surprise, but in this space, when they narrowed it down to 3 competitors, it's like kind of a pick 'em at the end. And don't forget, too, that Google was part of this prior. A few months back in February, the Defense Department narrowed down that list of contracts and excluded that vendor as well. So, and that was with PwC. So there were a lot of big players in this competition.
And the scope of this contract is pretty broad. You write, the system will be responsible for DoD's 9.6 million beneficiaries. Eventually, the software will be deployed at more than 1,200 sites and across 56 inpatient hospitals and medical centers. Now, that's quite a task. DoD also wants the system to be interoperable with the Department of Veterans Affairs and commercial providers. So why go with the so-called off-the-shelf product, Frank?
Well, I think this is reflective of what the Defense Department is trying to do in recent years with technology. They're kind of getting sick of building their own systems, and these systems don't often work very well and end up costing taxpayers billions and billions of dollars. You know, there was a similar deal a couple of years back when the Central Intelligence Agency went to Amazon to build a cloud. It was the same kind of deal where they said, all right, we're going to scrap building this on our own. We're going to bring in a commercial leader and have them do it. So it's the same concept here. Now, it remains to be seen how effective this move will be, but the interoperability by this product built by Leidos and the rest of them, it's going to have to be interoperable not just with the Veteran Affairs Department, but also with the private sector providers and even, you know, DoD's old legacy infrastructure as this, you know, goes down the line for years, because it's not going to be an instantaneous transformation. It's going to take 5 to 6 years before we really see these results.
Now, it's, of course, now the culture in Washington to automatically protest. CSC and IBM have about a week left to do so. What do you expect?
If I had to bet, I'd probably say we'll see a protest or two of this magnitude, so many billions on the table. If there was any issue with the evaluation that the bidders felt, you know, the Defense Department had, they will definitely raise it up. So we'll see. But we have 10 days, and if it happens, another 100 days before a decision would be rendered. So it would push the deal back, of course, and slow things down.
Well, keep us posted. We'll do updates here on Government Matters, but it's a big story. We appreciate you being here today. Frank Konkel with the Government Executive Media Group. Thanks again, Frank.
Certainly. Thank you.
On November 29th, the National Security Agency will change the way it investigates terrorism. So what happens to all the metadata they collected on American calling records? A top attorney from the Electronic Frontier Foundation joins me next. In Tech Matters, the future of bulk telephone metadata. The Obama administration says the National Security Agency will stop examining and ultimately destroy millions of American calling records collected under Section 215 of the Patriot Act. Joining me with the latest is Cindy Cohn, Executive Director of the Electronic Frontier Foundation. She joins us via Skype from Chicago. Cindy, in June, Congress passed a law ending that program. The public learned about it in 2013 after former NSA contractor Edward Snowden disclosed it to the press. A few days ago, the Director of National Intelligence issued a statement. Give us the basics of his announcement.
So the DNI said that he is going to stop collecting telephone records as of November 29th, 2015, which is 6 months after the law passed. That they're going to put them in kind of an intermediate place and not search them for 3 months so that their technicians can make sure things are moving smoothly. And then after 3 months, they're going to put them into something kind of like cold storage where they cannot get to them for ongoing use, but they're not going to destroy them until the civil lawsuits have resolved.
Now, there's an unknown here. DNI writes, separately, NSA remains under a continuing legal obligation to preserve its bulk 215 telephony metadata collection until civil litigation regarding the program is resolved or the relevant courts relieve NSA of such obligations. Cindy, DNI does not identify specific court cases. Were they brought by the Electronic Frontier Foundation? And in light of this announcement, will those cases be dropped?
3 of the cases that they're referring to were brought by the Electronic Frontier Foundation. And the problem here is that the government still doesn't want to admit that it collected anybody's telephone records. And until they agree that they did collect people's telephone records, specific people, including our clients, then they have to keep the evidence. Otherwise, we won't be able to continue with the case and determine whether what the government was doing was legal. So no, we're not going to be dropping the cases. And the government is keeping these records largely because of its own legal position and not because of us.
All right, so what happens on November 29th? How will the NSA obtain phone records?
Well, the NSA has to make targeted requests to the telephone companies using something called a selector. The exact definition of a selector is still a little vague, and many people are worried that they're going to read it very, very broadly and engage in still quite bulk collection. But theoretically, they're supposed to use an individual selector like somebody's email address and ask the telephone companies to give them information related to that email address, everyone who talks to that, I'm sorry, not email, telephone, that telephone number, everybody who talks to that telephone number, and everybody who talks to anybody who talks to that telephone number only. So it's still a lot of information that they're getting, but it's not the wholesale telephone records anymore.
Right. Cindy, before you go, I'd like to get your take on a related story. The White House just published a response to a petition on We the People, their online platform. Nearly 168,000 people asked President Obama to pardon Edward Snowden. Here's part of the White House response. Instead of constructively addressing these issues, Mr. Snowden's dangerous decision to steal and disclose classified information had severe consequences for the security of our country. Now, it suggests Snowden should have engaged in a constructive act of protest and that he should come home and be judged by a jury of his peers. Do you agree?
No, I don't. And I think it's very misleading. First of all, Mr. Snowden did try to bring this up, and I've represented other whistleblowers who tried to bring this up through appropriate channels, and frankly, they really aren't available to somebody in Mr. Snowden's position. Similarly, the laws that he's being charged under, the Espionage Act, have very, very serious penalties, and they don't have any ability for the court to consider the public interest in what Mr. Snowden does. So, if the government wants to clean up the laws and make them more reasonable for people like Mr. Snowden in the future, both to bring this information forward in the first instance and to face a reasonable balancing of penalties in the back, then we could talk about it. But I think they're trying to mislead the American people into thinking this is a simpler matter than it appears.
It's good to get your side of the story. Cindy Cohn, Executive Director of the Electronic Frontier Foundation. Thanks again, Cindy.
Thank you.
In Management Matters, political donations by government contractors. The presidential campaign season is already in full swing with 16 Republican presidential candidates and a handful of Democrats all vying for their party's nomination. Experts say it will be the most expensive campaign season ever. But a new court ruling leaves one group of prospective donors on the sidelines. For more, I'm joined by Tom Spulak. He chairs the Government Advocacy and Public Policy Group at King & Spalding, a law firm with offices around the world. So, Tom, a federal appeals court recently upheld the ban on political donations by government contractors. Give us the details.
Sure, Morris. Since 1940, there has been a ban on contributions and expenditures by federal government contractors. But in this particular case, the court addressed this on the challenge brought by some individuals. These individuals were not incorporated, and because of that, they could not have PACs. So they brought a constitutional challenge saying that they were being discriminated against, similar to government contractors who were incorporated. They did not have PACs, that their First Amendment rights were being abridged, and that the law should be struck down as unconstitutional. The court did not rule in their favor. The court said that there was a valid reason for the ban on federal government contract contributions, and that was to avoid quid pro quo corruption. The court cited numerous instances where prior to 1940, government contractors were either forced to make political contributions in order to maintain contracts, or in fact they offered contracts as bribes, if you will, to obtain them. So the court said that to avoid this corruption, the challenge would be struck down and that the law was constitutional. But really what this leaves open is an issue that has been around since the Citizens United decision 5 years ago. Citizens United, as you know, said that corporations could make expenditures in federal elections. Well, the question is, what about a government contractor? Could a government contractor make expenditures, or did this 1940 law somehow interfere with that ability?
Now, opponents of this ban argue different types of contractors are held to different standards. Here's how the Associated Press puts it. Challengers also complain that the law allows the president of a corporation with a multi-billion-dollar defense contract to make contributions contributions directly or through his company's PAC, but bans an individual with a $12,000 federal contract from doing the same. Explain that for us.
Well, that's a great question, and it's a very valid point, and it really comes down to the question of really what is a corporation. And so for the purposes of this law, the corporation is considered separate from any individuals who are officers or potential donors, as well as their PAC, because the PAC is a separate entity, and the money that flows into that PAC does not come from the corporation whatsoever, but from individual contributions of their employees. So, although it may not make practical sense in a legal sense, in that case, all the money is separate from the contractor. In the individual who is both the individual potential donor and the contractor, there is no separation. The money is coming from that individual's pocket. So again, I can appreciate the fact that some not versed in the law might say, yeah, that doesn't make a lot of sense. But if you focus on the fact that each of these are individual separate entities and the money is not commingled, that's how the law can make that distinction.
Now let's discuss awareness. Would this ban come as a surprise to a lot of individual contractors? What happens to them if there's a violation?
Well, it certainly could come as a surprise to individuals. The FEC has said that it would only be a crime if the person was aware of it and intended to make the contribution with that knowledge. So my sense is that there would be some lenity that would be extended in those circumstances where a person truly did not understand how the law applied to them.
Do you expect this case to go to the Supreme Court?
Perhaps, and the reason that I say that is, again, this case is more, at least for some of the parties involved, is more about what this means in terms of the Citizens United angle. Can contractors make independent expenditures? And again, that would apply both to corporations and individuals than just to this particular case, because again, as I said, it really has limited application to the broad government contracting world as it is on the books.
You've explained the issue well. Tom Spulak with King & Spalding. Thanks again, Tom.
Thank you, Morris.
And that's the latest from Washington. Thanks for watching. I'm Morris Jones. We know your week is filled with other matters. Save this half hour for us.